half, I mean, second half of the year 2026. Another 5-year plan. What is the source of funding? Whether the state is ready for the matching amount.
Yes, Your Lordship.
And there are many other things. This is an international responsibility as also
Your Lordship.
national responsibility. So what? Let's see the affidavit that you filed.
Your Lordship, I have not yet filed because I just have received an advance copy of the enclosure. If I may be allowed.
There has to be one sense of urgency because this question is going to crop up in Supreme Court. And even otherwise, forget
Yes,
about matter being taken up in Supreme Court. Even otherwise, it's necessary. We must know. We are monitoring. This bench has been monitoring.
Yes, Your Lordship. Your Lordship.
So when would you file it? I mean, whatever you have to give, then we'll issue directions.
Yes, Your Lordship. In that regard, if I may be allowed to at least produce the advance copy so that, because Your Lordship, the advance copy only contains the constitution of the authority, but there are no meeting minutes, Your Lordship. So in that regard, if direction can be...
What is that communication, if you could pass
Yes,
it
Your
on to us? See, this is only to show the urgency in the matter. You have to do it.
Your Lordship, I have paginated only the first 5 pages, and the annexures are also flagged as 1, 2, 3, 4, 5.
No, but this is, unless you put in, this would not be part of the record.
Yes, Your Lordship. If the blue flag, if I may, Your Lordship, if I may be allowed to refer to the blue flag, Your Lordship, that is page number 4, Your Lordship. So, Your Lordship, on the last para, which is indicated by the blue flag, it says here that the authorities shall constitute a technical committee to review brief documents, management plans, and advise on any technical matter referred to the wetland authority. A grievance committee consisting of 4 members to provide a mechanism for hearing and forwarding the grievance raised by the public authority. The authority shall meet at least thrice in a year. Now, Your Lordship, I have not been given information as to whether the authority set up in 2018 has ever sat for a meeting. And then, Your Lordship, on page number 5.
The matter concerns the conservation and protection of wetlands under the Wetlands Conservation and Management Rules 2017. Pala wetland is one amongst the identified wetlands as a Ramsar site in the state of Mizoram with an area of about 1850 hectares. This court on an earlier occasion had noticed the rules of 2017 framed by the Ministry of Environment, Forest and Climate Change regarding the preservation and management of the wetlands. A holistic, integrated management plan is necessary for the purpose. First up. This court also noticed that the management plan with respect to the year 2024 to 25 only has been provided. First up. Under aforesaid circumstances, this court had directed the respondents and particularly the Secretary, Environment and Forests and Climate Change Department to file a detailed affidavit with regard to future course of action for the court to appreciate the steps taken and the future management plan for conservation of Pala wetland. Ms. So-and-so, learned so-and-so, has submitted before this court today that instructions have been received and it shall be annexed with the affidavit which is required to be filed by a responsible authority in the Department of Forests and Climate Change, which shall be done by the next date. Re-notify on, we give you 3 weeks.
Much obliged, Your Lordship.
Re-notify on so-and-so date.
Much obliged, Your Lordship.
Item number 2. First item, date 15 July.
दूसरा slip लेते हैं. Yes.
My lords, this is a suo motu contempt petition, my lord, which has been registered. Now, my lord, as per the last court's order, notices were served to the respondents number 1 to 6. However, my lords, only respondent number 1 has been represented today. And then
Who appears for respondent number 1?
Lordship.
Now let us first deal with him, and then we will look at service of notice on respondents number 5 and 6. What do you have to say? Why should you not be prosecuted?
As if I have received an instruction, oral instruction from respondent number 1, then I may be allowed to file the affidavit.
You may file affidavit, but
No.
this court would brook of no answer, which is not logical.
Lordship.
There was an order passed by this court. Pursuant to this, the Mizoram Corporation, what is that corporation? Municipal Corporation of Mizoram has also issued an order. Of Aizawl AMC, Aizawl
AMC
Municipal
Lordship, yes.
Corporation. How could you defy that order? If you say yes for any reason, you are under contempt of this court.
Lordship, this
I
contempt
mean, you
petition
couldn't
is...
have taken it lightly like this. Put in your response, and we initiate a proceeding against you.
Lordship. Very true,
And in
Lordship.
that case, we may also ask for demolition. That can't be done.
Lordship, this contempt petition is arising out of the PAL number. Lordship,
Don't argue without a written reply. You are
Lordship.
under contempt
Yes,
of this
yes.
court.
Lordship,
A clear
I may be
contempt
allowed
of
to
this
file the vakalatnama during the course of the day. I have not filed
Therefore,
the
you are
vakalat.
safe for today.
Lordship.
You are safe for today, but think of an explanation. And it would be better if you demolish that construction without our directions and come back to us and say that now it was a mistake and we have rectified it. Otherwise, there is no reason for us to spare you. I mean, it's an open and shut case for a contempt case. Take. On 8/4/2026, this court, on finding that 6 persons had violated the court's orders and had proceeded to continue with the construction, notwithstanding a clear restraint by this court and a consequent order passed by the municipal corporation. What did I say? Notice was issued to all 6 of them, out of whom 4 have been served.
My lords, if I may, my lords, there is no return of service notice.
Just
upon,
hold on for a minute. We are taking it very seriously.
Yes, my lords.
4 have been served. First up, out of those 4 who have been served with the notice, Dr. Vanlal so-and-so, number 1 Lekhlanesma, has appeared through a counsel who is yet to file his wakalatnama.
Lordship, yes.
First up, he submits that he shall be filing his response to this application in the shape of a reply to the show cause notice to explain why contempt proceedings be not initiated against him. First up, the rest of the 3 who have been served are given one more opportunity to appear before this court through their accredited counsel for explaining their cause. First up, they awaiting the service of notice on respondent number 5 and 6. No, they report that the address is incorrect.
Correct. 5 and 6 incorrect. And my lord, this is one.
No, but what are you going to do about it? The registry will do. We have taken it on suo motu. The concerned police station. Again, the registry shall communicate to the officer in charge of the concerned police station for the service of notice on respondents number 5 and 6, and shall report to this court through the office of the additional, through the office of the additional, it shall report to the registry. Stop. Mr. Joseph L. So-and-so, learned amicus, shall also find out the correct and present address of respondent number 5 and 6. And in that event, we may direct for filing of, we may direct for issuance of notice on respondents number 5 and 6 thereafter on their correct and present address. Let this matter come up for consideration on, we give 3 weeks, 4 weeks? 4 weeks, after 4 weeks. Give the date.
22nd of July.
We make it very clear that in the interregnum, any construction activity in the prohibited area as directed by this court would be viewed very seriously.
My lords, I'm sorry to interrupt again, my lord. Two to respondents number 4, my lord. There is no return of postal receipt ID card, my lord. So, my lord, perhaps we can take steps by way of dusty upon them, my lord. I think that will be better.
The learned amicus has also offered to serve respondents number 2 to 6 dusty.
2 to 4, my lord.
2 to 4 dusty by dusty mode. Stop. The registry shall provide a format of notice to the learned amicus, who shall have it served on response number 2 to 4.
Obliged, my lord.
Sequencing उसका ठीक कर देना.
Item number 3.
थोड़ा सा सीरियस मैटर है. इसको स्टे तो आपने कर दिया. Everywhere now they have this ceiling of 15%, 20%, but they cap it with a condition that you possibly will have to come forward with the detailed analysis, detailed rate analysis, and justification of giving anything which is lower than the threshold rate.
What is happening now is all the tenderers are giving 5% below because they can afford.
And there is no guideline for selecting one amongst them. Correct.
And
So,
then
but
the
we
SOR,
can't,
the
we can't,
schedule of rate.
we can't,
schedule of
we
rate.
can't sort of keep that stay for a long time. Where is the affidavit?
My lord, I have received the Parwai's comments yesterday.
I
I'll
will
be
follow.
preparing, my lord, if it can be listed again in the next week for final
No,
hearing.
it shall be listed in the next week, that's true. But then with the stay operating on that notification,
Yes,
perhaps no tender could be floated.
Yes, my lord.
Now what you have to do is this. We are not going to suggest it in our orders. What you're going to do is this. You have to ask the authorities to at least find out that this practice of asking for no less than cap of 5% low or 10% low or 15% more, this is all right. This is being practiced everywhere in the country. But then with an additional requirement that in case lower than the threshold is
Yes.
that bid value is furnished, that bid value is staked, then they have to come with correct rate analysis with photographic evidence of their infrastructure, of everything, of ongoing projects. And once they demonstrate, then they fall in the category of such bidders who could be considered.
Yes.
So this one thing will cure the entire defect. And number two, if that is the lowest rate possible, 15% less than the fixed rate, or 5% or 50, whatever, then everybody would file that rate.
Yes.
In that case, the authorities will have no guidelines to select from whom.
That is
So that also would be taken care of if the detailed rate analysis and the infrastructural documentary evidence, photographic evidence is given for the authorities to select one amongst them.
Yes.
So because of the state not coming with the affidavit, the state keeps on operating, which is not good for you. Construction work has to go on.
Yes. That is
Considering the present day scenario, of course, with the restraint of not making constructions in hilly areas and causing any environmental degradation or something. But then you are delaying it.
yes, my lord. I'm sorry to say that it was vetted by the
You
law
means your
department.
client, not
Yes,
the
ma'am.
advocate in his personal in his or her personal capacity. But you have received instructions. You should have filed.
Yes, my lord. Yesterday only I've received, so I'll be filing it with by tomorrow, my lord.
Miss Rosalind, so is a pura naam likhna.
Linda.
She's Linda.
Linda.
Linda Fambol.
Fambol.
Sorry, MS Linda Fambol. Your additional advocate?
Yes, my lord. Additional AG.
The learned additional advocate general, State of Mizoram, submits that instructions have been received by her with respect to the tender condition, with respect to the desirability of the notice of the notification dated 15/7/2024 and necessary affidavit in that regard as directed by this court on 25/2026 shall be filed positively by the next date. Re-notify on. We give you 2 weeks, but that's the end.
My lord, 17, next week, my lord,
Huh.
since there's a stay.
All right. Next week date.
17/6.
76.
Obliged.
Item number 4.
अच्छा प्रोसेस है सब चेक करो.
I'm sorry to say that, my lord, this also I've received it the last minute. Just this morning I've received the instructions. I can file it, my lord, in the form of affidavit.
Establishment of open correction.
Correct. Please tell us please show us the last of the orders of this court. Is it 8/4/2026, Mr. Malhotra?
13/5. 13th of May.
13/5.
Just give us 2 minutes. Now 3 months have passed, no? After
Yes.
that judgment of the Supreme Court in which was that case?
Yes,
Suhas Chakma.
So, yes.
So 3 months have already passed.
Yes, my lord.
What do we do about it?
My lord, the state government,
The thinking period is over. I think it had to come on the ground. What have you said? What instructions have you received?
my lord, I'll give it to you.
No, you tell us what instructions you
My
have
lord,
received.
the Home Department has constituted a state-level monitoring committee to assess the feasibility.
That is long time back.
Yes, my lord.
Then thereafter what happened?
My lord, the guidelines for the operation of OCI are contained in the Mizoram
No,
Prison
don't
Manual.
read that. Now tell us what is the decision?
The decision.
Have they found out the feasibility? I read a news in Gauhati about 6 of the juveniles having run away from the correction home.
Yes.
What has happened about that? Takes one more notice, no? Takes one more notice. Gauhati Center. Just ask one. You have to inform. Just a minute,
Yes,
Ms.
madam.
Linda. You have to take instructions with respect to that. We are digressing, we know.
All right.
But you have to take that information and get back to Justice Michael. We'll take it up as suo motu PIL. Just
Those
take
was running away of those
Juveniles.
juveniles. Yes.
take instructions.
Yes,
Get
madam.
back to Justice Michael. He will put up a note and then we will take it up.
My lord, in the instructions I have received, the government has taken steps for shifting of district jail, Aizol, to a new location. And the proposal for construction.
Put it in black and white.
Yes, my lord.
Next
I
week
can-
again.
All right.
Take down. Mr. A.R. Malhotra, learned advocate for the petitioner, no? Learned advocate, amicus or petitioner? Learned amicus has drawn the attention of this court to the order dated 26/2/2026 passed by the Supreme Court in WPC number 1082 of 2020, bracket Suhas Chakma versus Union of India and others, as also the order dated 13/5/2026 passed by this court Stop. By the aforenoted order, the respondents were required to comply with the direction for establishment, comply with the direction of establishment of open correctional institutions after making an assessment about its feasibility and the necessity. Stop. Ms. Linda L. Fambol, Learned Additional Advocate General, has submitted today that instructions have been received with respect to the final decision of the state in compliance of the order passed by the Supreme Court in the aforenoted WPC number 1082 of 2020, bracket Suhas Chakma versus Union of India and others, bracket close, referred to above, and necessary affidavit in that regard shall be filed positively by the next date.
All right.
We keep it again in the next week.
All right.
3 months have already passed. Please
Yes.
take note of it.
Yes, my lord.
Otherwise, the contempt petition will not lie here. The contempt petition will go before the Supreme Court.
My lord, we are taking steps.
And they are not lenient, and they should not be.
17th June.
And please, we are asking you to give information to my brother
Yes, my lord.
with respect to running away of juveniles. That's a request that has been made by the bench. You please tell us, because that's a serious matter. We must look at it. You being the Advocate General is not here now.
No, to be continued.
You take all instructions, contact the representatives of the government, and immediately get back to us what has been done.
All right, my lord.
On newspaper report also we could have taken notice of it. But then you tell us
All right, my lord.
by tomorrow.
Bye tomorrow.
Item number 5.
Item number? For details order karna, appeal has to be admitted.
May I please, Your Lordship, this criminal appeal relates to conviction and
Correct,
sentence
so
under
it
the
has to be
POCSO Act.
admitted. Lower court records have to be called for. Notice to a Microsoft.
The notice to the informant.
It is admitted. Trial court records have been called for.
Notice
The
to the respondent.
paper book called notice to the respondents, complainant, and notice to the informant.
Notice to the informant.
Format of notice and all. whichever regular-
Oblige, Your Lordship.
This on 24th of June. Item number 6.
Naam de zara. Appearance slip of all new advocates. I don't know the names, na? Immediately, huh?
Please, Your Lordships. My Lords, this
Yes.
may it please, Your Lordship. My Lord, this is regarding that promotion of Havaldars to SI.
Correct.
So we are challenged. We please
On,
the challenge.
on 17 to 2026, we
Found
almost rejected your arguments.
Until we found some anomaly in the
Only
marks.
with respect, yes, the affidavit which we wanted.
Yes, Your Lordship, I have filed the affidavit in compliance with the order on 12th March 2023. And Your Lordship, in the affidavit, we have stated that there is a
Where is that affidavit? Which page do we find it? The page. Just. It's very vague. We wanted to know whether one mark would have made a difference between these appellants and respondents number 7 to 24, their positioning in the list. Somebody would have gone out, somebody would have got in. So that statement you have not given. You say that it was a typographical mistake, correct? Typographical mistake, we don't take notice of it presently when others are working. But then if it would have made a change and somebody from the list of the appellants would get in, where is that statement? And this is a casual filing of the affidavit. We wanted some other thing.
I understand.
Even if it be for one, that makes a difference.
In fact, Your Lordship, after some scrutiny, I found that there are two more anomalies, in respect of two more selected candidates.
Mr. Alpha, the difficulty is that now much water has flown. I mean, I don't know which river flows through the state of Mizoram.
Klong.
But much water has flown now.
Understood, but
they are
then-
working.
So, with Your Lordship's permission,
Yes.
I would like to place some questions in reply to their
No,
affidavit through this bench.
we had almost
Just-
closed the arguments on that day.
No, madam,
unless it will make very dramatic changes in the list. I don't
hope
think
so.
we should continue with that any further. You have made your case, you have argued, we have
just-
dealt with all your arguments.
Just in reply to the affidavit filed
No,
by my
this
learned
affidavit is nothing. We are rejecting
Understood,
this affidavit
understood.
today.
So what they're saying, the reason why is that it's contradictory to the previous reply that I've received. The reason being is that, Your Lordship, as per my understanding of the RTI Act, they're supposed to provide us with a copy of the original set. They're saying that since the RTI application, there was a typographical error.
Yes, that again.
That's number one. May I, if Your Lordship can kindly indulge me for just 2-3 minutes.
Yes.
So if that is the case, that means that the final tally which they relied on some data, that has to be relied on some other data because this is a computer entry. So, and in my RTI reply dated 21 March 2024, they specifically told me in the RTI reply, which I have annexed in my appeal memo.
Mr. Alpha, did you ensure by the writ court, and did you ask for it that the record should be maintained, because 6 months and they destroy the records except the final tally?
No, we have mentioned that because the RTI reply which I'm speaking of right now, that was annexed. Because in the RTI reply which was provided to me in 2024, they specifically told us that the records are not at the police headquarters. So if that is the case, and they're saying that it's a typographical error, what is the basis of coming to the conclusion that it's a typographical error when the records are not there?
Correct. I think you make sense. Yes? Can I make
Yes, Your Lordship. If I may be given to file another affidavit in that
No,
regard.
but can we ask you to improve upon your case now?
No, we are not asking.
I'm
I'm not.
I'm addressing her.
I apologize.
She's an additional government advocate.
In order to clarify that, Your Lordship. If I may be
Now this
allowed
is,
to take
I mean,
instruction.
you would file an affidavit on the asking of the court, and then you will explain and you will fill up the lacuna, and then I think Mr. Lal Fakoma is correct that you don't have anything to say. Look at the affidavit, what you have said. Look at paragraph 2. Therefore, in compliance of this court's order, it is submitted that the information furnished in the Right to Information Act. What is this information? That information is there with him. That information is there with everybody who would file it. Now, we had asked you to say that, assuming that it was a typographical error, and instead of 8 marks, he was given 9 marks, that one particular person, respondent number 21.
Yes.
So, would it have made a difference? Would he have gone out if the marks tally were like that? That this anomaly, this typographical error, we are not concerned with. It happens. It can happen, though there is no justification for the same. You're dealing with the lives of young people. But then look at the information, the source of information, RTI information. You had to say that from the records we have found. Now this is just a formality, because the court has asked you to do. You have filed 2 pages affidavit without giving us the details. We reject this affidavit straight away, with a note in our order, which we don't want to do because I am here for only 2 days. This affidavit doesn't satisfy us. We have almost closed the case, haven't we? We have almost closed the case, and you are not taking it seriously. We need to know, now try and understand. He is absolutely justified in saying so. Your information is based on RTI information. We are not concerned with that. Now this source is good enough for you to say and you to confess and admit that it was an error. The respondent number 21 should have been given 8 marks on that particular slot. So far so good. But you have to make a scrutiny and say whether 1 mark, you have to reduce 1 mark from the total tally of respondent number 21 and then see whether anyone is coming in or going out. Where is that information? This is a very vague kind of an affidavit. Take it.
May please, Your Lordship, just one point. I just want to bring to your...
There has to be an end to litigation, Mr. Alfagoma.
Understood. The same affidavit will cover this point. In respect of serial number 15, who is respondent number 22. 16.
Have you responded to this affidavit?
He is a respondent.
Have you responded to this affidavit?
No, this is the first time it's coming up.
The first time it's coming up.
Since the last order.
But the copy must have been served upon you.
Copy has been served.
So you should have filed some objection to this affidavit that this is incorrect.
I have to take leave of this honorable court to do that also.
Is that so?
As per my understanding.
You can always prepare it, ask for the leave. We would have allowed you to. I'm sure this court would allow you to file it across the board. We'll accept it on record.
My lord. So, in respect of this serial number, mind you, Your Lordship, top 18 were supposed to be selected. In respect of candidate number 60, who is at serial number 16, in the overall mark, he was also awarded 9, but in the RTI reply, he was given 8.5. So, there's a 0.5 difference. So, the last 3-4 candidates will have a big difference.
So, therefore, what you're driving at is that deliberately more marks were given to them to make them to make them occupy the seats. We have been rather indulgent with the respondents,
Your Lordship,
not the private respondents. But you have not answered our query.
Your Lordship, if I may, in the last court date, that is on 6/5/2000.
Now, what will you say? You have no
No,
basis
Your
to
Lordship,
say.
what I have to say is that the learned counsel prays to submit additional affidavit. Written objection in my affidavit. So the court has granted that one.
Don't try to pass on the buck, no? That's
But
not
he
done.
has asked the
We are
court
here.
and the court has granted him.
In fact, I would request you not to take it as an adversarial litigation, even though it is. But we are not taking it as an adversarial litigation. We just want to find out. Anyway, you file another affidavit. We are rejecting this affidavit. Taking notice of the submissions made on behalf of the appellants, this court, by order dated 17/2/2026, had directed the respondent state to furnish an information with respect to the correctness of the list if one of the private respondents, namely respondent number 22, was given 1 marks extra, and whether it was a typographical error. The affidavit filed on behalf of the state is apparently based on the RTI information, and it only answers one of the queries of this court, that instead of that there was a typographical error in awarding 1 marks more to respondent number 22. The concern of the bench was whether 1 mark more to respondent number 22 would have made any difference in the overall tally, which would have rendered him outside the scope of consideration, while any one of the appellants would have got in the range of being considered for selection, for promotion. Ms. So-and-so, learned government advocate, seeks permission of this court to file a supplementary affidavit with the necessary information as desired by this court. Let such an affidavit be filed positively by the next date. Re-notify on. We are giving you 3 weeks.
My lord, that marks anomaly in respect of the private respondent number
You
22
should have
as
brought
well.
it on our notice. No, we can't do that unless we are limiting it to the query which we made.
21.
Very well.
15th of
Right.
July. Item number 7.
Okay. Yes.
May it please your lordship. My lord, this is a jail appeal arising out of District and Session Judge in criminal trial number 674 of 2015, wherein
Yes.
the appellant has been convicted under section 302, 302 IPC and RI for life, and in default 10,000 fine for 1 year. There are as many as
Now let us see the charge first.
yes, my lord.
Come to page 2 of the brief. Show us. Just read.
2, my lord. 2 and 3. Yes, my lord. The appellant has been charged under section 302 IPC.
You read the charge, no?
Yes, my lord. If I may read that, you in between 11 p.m. of 31/12/2014 and early morning of 1/1/2015 committed murder intentionally causing the death of Lalan Moya Zadeng and thereby committed an offense punishable under section 302 of the IPC and within the cognizance of this court. Secondly, that you in between 11 p.m. of 31/12/2014 and early morning of 1/1/2015 committed murder punishable with death has been committed, did cause certain evidence of the same offense to disappear, and thereby committed an offense punishable under section 201 of IPC and within the cognizance of this court. Thirdly, that you in between 11 p.m. of 31/12/2014 and early morning of 1/1/2015 committed theft of scooty bearing registration number MZ01J6893, helmet, Apple iPhone 5C and wallet containing money belonging to the victim Lalan Moya Zadeng and thereby committed an offense punishable under section 379 of the IPC and within the cognizance of this court. Fourthly, that you on early morning of 1/1/2015 forged the number plate of scooty from MZ01J 6893 to MZ01K 3085 and thereby committed an offense punishable under section 465 of the IPC and within the cognizance of this court. Fifthly, that you on 1/1/2015 onwards, you fraudulently used the said number MZ01K 3085 as a genuine one, which you knew at the time when you used it to be a forged document, and thereby committed an offense punishable under section 471 of IPC and within the cognizance of this court. Lastly, that you on 1/1/2015 onwards, you use false property mark, registration mark on the said scooty, and thereby committed an offense punishable under section 482 of IPC and within the cognizance of this court. And I do hereby direct that you be tried on the said charge. Do you understand the charge framed against you? And he answered yes. Do you plead guilty? No. So that was the charge framed against him, my lord.
Now read the FIR.
It's at page 1, my lord. Submission of to the officer in charge, Bongpom Police Station. Submission of inquiry report and registration of case. Reference is Aizawl Police Station. So with reference to the above, I have the honor to report that on 2nd January 2015 at 8 p.m., a written information was received from F. Lalian Sang of Electric Wing, Aizawl, to the effect that on the night of 31/12/2014, around 10 p.m., his cousin Lalun Moy Zading, 35, son of Lal Sabunga Zading, late of Babutlang, Zarkot, left their residence by using scooty rodeo RZ black color bearing registration number MZ01J 6893 to roam about, but did not return home till date and requested to take necessary action. Hence, the matter has been inquired. During inquiry, it was ascertained that the said Lalun Moy Zading visited the house of Zauram Thari, daughter of H.K. Dala of Bongkon, Lunglei Road, on the night of 31/12/14 and left the said house between 11 p.m. and 12 p.m. towards unknown destination, and his whereabouts was untraced. Search for the missing person was conducted at different places with the help of Zarkot Branch and Central YMA within Aizawl City and other neighboring areas. During further inquiry, the dead body of the said missing person, Lalun Moy Zading, was recovered in a state of highly decomposed at the area of Falkland Vainthar on 8/1/2015 at around 4 p.m. Inquest was conducted over the dead body, and one suspected cut injury mark below the chin and suspected injury on the occipital was found. The wearing jacket of the deceased stained with suspected blood was recovered and seized along with silver ring, bracelet, and wristwatch. The dead body was later found to forwarded to Forensic Medicine and Toxicology Department, Civil Hospital, Aizawl, for conducting post-mortem examination to ascertain the actual cause of death. During further inquiry, spot verification was conducted and found out that vehicle scooty rodeo RZ driven by the victim on the night of 31/12/2014 was missing, along with Apple iPhone 5C, having SIM number 977432791.
All right, who is the investigating officer of the case? PW?
1.
PW1.
Yes, ma'am.
Come to his evidence.
78. One is at page 78.
Yes.
My lord, he was the one who submitted the inquiry report, PW1.
Has he investigated the case?
Who
is the investigator of the case?
What is the investigating officer?
Anyway, you can read this. This is important. Read this, it's important. Yes.
On the night of 2/1/2015 at 8 p.m. while performing duty at Aizawl PS as duty officer, a written information was received by me from Shri F. Lalian Sang of Electric Wing Aizawl to the effect that on the night of 31/12/2014 at 10 p.m. his nephew, Lal Nunmoy Zadeng, son of Lal Thamwana Zadeng of Babut Klang, Zarkot, had left their residence by riding scooty rodeo RZ black color number MZ01J6893. Lal Nunmoy did not return home till the date of information and requested me to take necessary action. On the basis of the written information, the OC of Aizawl PS detailed me to conduct the inquiry. Accordingly, matter has been inquired into. In the course of inquiry on the night of 2/1/2015, matter was informed to all the police stations within Mizoram by WT message and WhatsApp message. The matter was also informed to news editors. Complainant was also a news editor of Zonet Media. We pursued the matter by visiting different places within Aizawl district. On 5/1/2015, I came to know from one of the local leaders of Zemabog branch YMA, namely Lal Rautuanga, son of Vanal Soma, over mobile phone that Lal Mga Isanga at Patia, son of Zausang Puig, Zemabog, found one wallet containing one HDFC bank credit card number 4617-864001576665, Platinum Plus, driving license number MZ01200900366146 in respect of Lal Nunmoy Zadeng, was the missing person, and 3 HDFC card number
Leave those details.
Sorry, my lord.
Leave those details
Okay.
and come to the last paragraph. I then seize the above articles.
Yes, my lord. HDFC Bank visiting
Last 4 or
card.
5 lines in
Last
that
4.
paragraph.
Okay. I then seized the above articles in the presence of reliable witnesses, namely F. Lal Biakdika, son of F. Thangzava, Zemabo Galilibeng, and Lal Rautluanga, son of Vanal Som, at Zemabo Community Hall, and recorded their statements. I came to know from Sri Lal Rautluang and others that the mother of Lal Mga Isanga informed the local leaders of Zemabo branch YMA that Lal Mga Isanga had found from the dumping ground on 3/1/2015. In the statement of Lal Mga Isanga, when he saw the photo of Lal Nunmoy Zadeng, who had been missing from the night of 31/12/14 in a local TV, he thought that the wallet belonged to Lal Nunmoy Zadeng. Then he informed his mother about the recovery of the wallet. Thereafter, the mother of Lal Mga Isanga informed the Zemabog branch YMA leaders. The Zemabog branch YMA leaders then had a committee in order to know whether the owner of the wallet was the same person who was missing at that time. On 8/1/2015 at 4 p.m., we received a phone call at Aizawl PS that one dead body was found at a place below Falkland Church.
been identified.
I then informed my superiors
This
and proceeded to the
complaint.
spot where the dead body was recovered. When I reached the spot, there were many civilians and few Bongkon PS personnel gathered. Thereafter, I told the policemen present to demarcate lines so that the civilians would not come close to the place where the dead body was lying. I examined whether the dead body belonged to the missing person by comparing the photocopy of the missing person. At the relevant time, the complainant F. Lalian Sanga also reached and identified the dead body to be that of Lal Nunmoy Zadeng. Before holding inquest, I seized empty mineral water bottle, Kinley, silver ring jacket which covered the dead body, disposable cup, empty mineral water bottle, Kingfisher, phone cover, silicone, empty quarter bottle glass, blue color underpant, empty shopping bag, bracelet, steel, Timex wristwatch, square gold and silver, and syringe in the presence of 2 witnesses, and recorded their statement. I held inquest over the dead body in the presence of 2 witnesses and recorded their statements. There was cut injury on his frontal neck and there was also laceration on his occipital region. We suspected to be a murder case due to the injuries found on the dead body of Lal Nunmoy Zadeng. Thereafter, I forwarded the dead body to the medical officer to hold post-mortem examination at Civil Hospital Aizawl. Accordingly, the dead body of Lal Nunmoy Zadeng was examined. I then handed over the dead body of the victim to his relatives for disposal. Hence, I submitted inquiry report to the OC Bolpon PS in form of FIR to register the case. And he has exhibited all the seizures. Exhibit. My lord, should I read the exhibits? P1 is the inquiry report submitted by me. P2 is the seizure memo and exhibit P2 is my signature. P3 is the seizure memo, P3A my signature. P4 inquest report, P4A is my signature. P5 is the challan for PME and exhibit P5A signature is my signature. And P6 is the command certificate deputing C31 Lom Sangpuya of Aizol PS to proceed to civil hospital Aizol and to escort the
Correct,
dead body.
we have seen. Now, tell us whether Henry and Daniel have been examined as witnesses.
Yes, my lord, they have been examined as witnesses. Their examination.
Henry is PW,
Daniel is PW number 15 and Henry is PW number 16. Daniel's examination is at page 103 and Henry's is at page 105.
now let us see Daniel first.
Yes, my lord. If I may read.
Page
Page 103.
100.
103.
Yes.
If I may read, my lord.
Yes.
I have been knowing the accused Vanlal Ramrao Puya since my childhood, as we are from the same locality. We are very good friends. On 31/12/2014 at 7 p.m., I, along with Pari, Tetei, and Lelvin Hima, went to TNT to watch the concert, but we returned as the concert was already over. At about 8 p.m., we gathered at Zotsunga bus terminal. While sitting at Zotsunga bus terminal, we had some snacks from the stall nearby. While sitting at Zotsunga bus terminal, Henry Venpuya, who is not Lelvin Hima, and the accused Vanlal Ramrao Puya joined us. After that, we moved to Chuampui Bazaar and made a fireplace and sat around. At about 1 a.m. on 1/1/2015, Henry, Venpuya, Tete, and Pari left the Chuampui Bazaar and proceeded towards Pari's house. However, I and accused Vanlal Ramrao Puya stayed back at Chuampui Bazaar. After some time, accused Vanlal Ramrao Puya disappeared from the place where he had sat. I proceeded towards Pari's house to join my friends and had some snacks and were listening to songs. Later at about 3 a.m. on 1/1/2015, I, along with Henry, went towards our respective home. Before reaching our house, accused Vanlal Ramrao Puya approached us by scooty, rodeo black. At that time, I asked him how he got the scooty, to which he answered that the scooty belonged to his girlfriend of Pulikon and told that she allowed him to use the scooty as it was late night. Thereafter, accused Vanlal Ramrao Puya took me and Henry on the said scooty and we had a ride within Aizol city up to Zaudin Square. Thereafter, we returned towards my residence. The accused dropped us near my house and he proceeded down the road alone. While dropping, it was twilight. After many days, we came to know from news that one person was being searched by YMA as he was missing. Henry told me that he suspected that the scooty which was kept by Vanlal Ramrao Puya might have been that of the missing person. After that day, Henry's mother told me that the police personnel summoned Henry and Venpuya, and she also said I was required to go to Bongkon PS. While trying to proceed towards the Bongkon PS, accused Vanlal Ramrao Puya called me and told me that he would accompany me to the Bongkon PS. Thereafter, I and accused Vanlal Ramrao Puya boarded in a bus at Chuampui to Bongkon PS. In the bus, accused Vanlal Ramrao Puya told me that he presumed that the police might have called us because of the scooty. Vanlal Ramrao Puya further stated that he had got the scooty from a man from San Mari in exchange of heroin as a security. After sitting at the PS for some time, I and Vanlal Ramrao Puya returned home. On the way home near the Mandir, accused Vanlal Ramrao Puya was apprehended by the police. Exhibit P11 is my judicial statement recorded by Sylvie Magistrate and P11A is my signature. If I may read the cross-examination.
No, we are yes, cross-examination. Yeah. That is the evidence.
It is a fact that I started to know the accused since I was 12 years old and we attended LB Memorial School, Chuampui together and also the Sunday school from junior department to senior department. 2. I found it a little unpleasant to make my statement today in the court since we were close friends. Number 3. It is a fact that I never ever found any bad character in the person of the accused Vanlal Ramrao Puya when we were close friends together. I could not believe and still cannot believe that the accused Vanlal Ramrao Puya could have committed such heinous crime for which he is being tried today. 2024. It is not a fact that I have today made my statement here in the court as I did before the judicial magistrate on 24/2/2015. Number 5. It is a fact that when the accused Vanlal Ramropue dropped us, dawn was already beginning to appear and it was 1/1/2015 morning. 6. It is not a fact that the accused did not say that he got the scooty as a security for giving heroin from a man from Tan Mari. 7. It is a fact that I cannot say the date when the accused was apprehended by the police. 8. It is a fact that I feel very sorry for Vanlal Ramropue for having such a big case against him and I wish him good luck in the future. It's not a fact that I'm deposing falsely in the court today. That's the deposition and cross-examination of Daniel Milsomzwala. And 105 is the deposition of Henry Lal Mwanpuya.
Correct. Now come to PW20. He is the person who knew about iPhone pawning. Is that correct?
Yes, my lord.
Come to PW20 now.
PW20, page 118. If I may read.
Yes, page?
Page 118.
Yes.
If I may read, my lords. I know the accused person who is present today. He is being my friend since childhood days. I am a resident of Chuampui Venglai. On 4/1/2015 at around 9 a.m. before morning meal, I visited the residence of the accused. We went out with the scooty kept by the accused. When I asked about the scooty, the accused replied me that the scooty was belonging to his girlfriend. The accused did not mention the name of his girlfriend. The scooty was black in color and its name was Rodeo. The accused proposed to sell my mobile phone, to which I agreed and sold it to my friend Lal Duoma at the cost price of rupees 1,500. The said Lal Duoma paid me 1,000 rupees immediately, and at evening he paid me the balance amounting to rupees 500. As rupees 1,000 was not sufficient for the purchase of drugs, the accused requested Zongmingi, his friend, to lend him rupees 300. She accompanied the accused to the ATM at Bongkon, took the money and gave him. Thereafter, I and the accused went to purchase drugs. As the accused was not satisfied with the drugs consumed, he proposed to pledge one white iPhone kept by him, which he told me that it was belonging to his girlfriend. The accused then pledged the iPhone to Zongmingi. The accused told me that Zongmingi paid rupees 1,500. Thereafter, the accused bought drugs, but I do not know where the accused had spent all the money. The police arrested the accused on 9/1/2015, and on 10/1/2016 at evening, the police picked up me and asked me about where the iPhone was pledged by the accused. I accompanied the police to the residence of Zongmingi. The police seized the iPhone from Zongmingi, and when the seizure was made by the police, I stood as a seizure witness. Mangay, who is the relative of Zongmingi, also stood as seizure witness. As far as I know, the seized article, that is iPhone, was handed over by Zongmingi. It is also that I also wrote the said scooty. Exhibit P8 is seizure memo in respect of iPhone in black and white color, and Exhibit P8B is my signature. M2 is the iPhone pledged to Zongmingi by the accused in my presence, and M8, Exhibit M5 was a scooty ridden by the accused in my presence.
Cross-examination we have read. Now you tell us who identified the telephone.
The phone was identified in the court by PW number 20 and even Zongmingi.
Now where is that forensic evidence which says that there was tampering with the telephone and another? Is there any tally of, is there any evidence of purchase of that mobile phone in the first instance? And it's, what is that number called? The number which does not change unless it is effaced.
Yes,
Different SIM cards can be inserted in it, but there is a big number, 8-digit number, which does not change. Now, is there any invoice or any evidence with respect to purchase of the mobile phone?
Yes, my lord.
Well, there is a case of circumstantial evidence. If we keep aside the confession, which shall not be looked into, so we have to find out See, this scooty and iPhone and tampering with the iPhone and that iPhone being in possession of the appellant, these are two very strong circumstances against him.
Yes, my lord. And my lord, he
So where
does
is
not
that
deny
evidence?
that,
Where is that evidence?
okay, my lord, it is at page 134 to 135. The PW
That,
number.
has that lady been examined?
Yes, my lord. She's PW number 29.
Okay. Now, which page were you referring to now?
134, my lord.
That is whose evidence?
Evidence of Rose Rinmoy. She's a branch operator manager at HDFC Bank, Longklai. If I may read my
Yes.
From the month of May 2013, I was working as assistant manager HDFC Bank Longklai branch, Longklai. And in the month of August 2016, I was promoted to the post of branch operation manager. As far as I know, deceased Lal Nunmoy Zading started working as deputy manager HDFC Bank Longklai branch before I joined Longklai branch. I came to know the deceased Lal Nunmoy Zading since I started working in this HDFC Bank Longklai branch. I knew that the deceased Lal Nunmoy Zading bought one mobile handset iPhone 5C from Rainbow Electronics Store Shop, Zarkot Aizol, for about rupees 38,000 to 40,000 in the month of December 2014. Since I have been using the similar mobile handset, I was acquainted with handling iPhone. Since the deceased Alal Nunmoya wasn't aware of initiating the phone, I helped him setting the phone by creating Apple ID and screen lock, and I also put the phone name as Moitia's iPhone 5C. After the dead body of Lal Nunmoy Zading was recovered, the police had seized the iPhone which belonged to Lal Nunmoy Zading. The phone was activated by taking to the shop. As soon as the phone was activated, I could trace the location of the phone because I had saved the Apple ID and password of the deceased, Lal Nunmoy Zading. While doing so, I came to know that the phone name was already changed to Puipuya's iPhone instead of Moitia's iPhone 5C.
Who is the apparent?
Puipuya is the appellant, the nickname of
And
the
Moite
appellant.
is the deceased.
Yes, ma'am.
Zading is the deceased and Kuku is the... Yes.
I informed the police personnel who examined me that Lal Nunmoy Zading's phone's name was changed from Moitia's iPhone 5C to Puipuya's iPhone. However, password and ID was not changed, for which I could locate Moitia's phone from my phone. Since I recommended the white color for Moitia's phone, now I am shown the iPhone which is marked as Exhibit M2 by the court, and I could identify the phone which is shown to me.
Has the shop owner been examined?
Yes, my lord.
Where is he?
Yeah, the shop owner is page 125.
No, PW.
PW number 24.
1 minute, you complete the cross-examination of this branch manager,
Yes, my lord.
operation manager.
Yes, my lord, if I may read. Cross-examination of PW number 29. There is no any full form of HDFC Bank Limited. Number 2, it is a fact that I was not at Aizol when the deceased Lal Nunmoy Zading purchased iPhone 5C, but he talked to me over phone and I suggested the white color. 3, it is a fact that I put the phone name Moitia's iPhone 5C when he returned to Longklai. It is a fact that the police did not come to me in person but only talked to me over phone, and I stated to them what I have said in my examination in chief. It is a fact that I did not put any personal mark or impression on the handset iPhone purported to have been belonging to the deceased Lal Nunmoy Zading. It is a fact that though there may be tens of white iPhone handset, I could identify Exhibit M2 as belonging to the deceased Lal Nunmoy Zading because I find it very similar to that which belonged to me. It's a fact that nobody had ever spoken that the deceased Lal
Correct.
Nunmoy...
Now come to PW 24.
Yes, my lord. PW 24.
125.
125.
Yes.
Yes, my lord. If I may read. I am working as a manager in Rainbow Firm Mobile Shop at Zarkot Main Street near Traffic Point. We are dealing in different kinds of mobile phones, including iPhone company. When consumer purchases mobile phone, we used to give retail invoice through computer from June 2014 to till date. Whatever we sold, all the sold invoice of mobile phones have been stored in our computer since June 2014. As per our record, 1 lal nunmoy zadeng of Zarkot.
Yes, I was referring to IMEI number. That does not change.
Acha, yes.
Yes.
One lal nunmoy zadeng of Zarkot purchased one Apple iPhone 5C 8GB, IMEI number 358549052455866 from our shop. If any consumer had any phone number, we used to write down on the invoice. In case of Lal Nunmoy Zadeng also, as he provided his mobile number, we wrote down his mobile number in the retail invoice. One police officer came to our shop and requested us to check our records and to print out retail invoice in respect of the purchase of Apple iPhone 5C by 1 Lal Nunmoy Zadeng. Accordingly, I told my staff to print out the retail invoice. Cross-examination. Number 1. The proprietor of the firm where I am employed is Rosang Liana Royte Khatla. I have been working in the firm since 2009. We are renting building of Puzausang of Zarkot at the price of 32,000 per month. I do not know who came and purchased the iPhone from our firm and whether the purchaser was female or male. I cannot exactly say how many persons purchased our mobile phone on 19/12/2014. The iPhone which was sold to Lal Nunmoy Zadeng cost rupees 32,500. I cannot say how many persons purchased the iPhone from our shop that day. If any consumer lost his retail invoice, we can issue duplicate retail invoice to him, and this invoice can also be treated as warranty card. I do not know the name and rank of police officer who came to our shop. We issued the retail invoice of Lal Nunmoy Zadeng only since the police officer demanded the same. Retail invoice which we gave to Lal Nunmoy Zadeng is not the same copy of the retail invoice which is produced before me today at Exhibit M7. It's not the fact that I am deposing falsely in the court.
Has Rosie been examined?
Yes, my lord, I just read Rosie's examination, which
Page 134.
Oh, we were reading 134.
PW number 29, 134. I read, she was the HDFC manager in at Longklai.
She is Rosie. All right. All right.
She was the one who suggested Moitia to buy the iPhone.
Where is the Caesar memo of the phone?
383. My lord, the seizure memo is at 386, page number 386. It was seized from Zhongming Liani, Chuampui.
Zomungliani has been
Cited.
examined?
Yes, my lord. She has been cited as PW number 3.
PW number?
3, which is at page 83.
See, this is good enough. IMI number confirmed.
But the Caesar memo was not.
But then let us see her statement. Yes, read PW3.
Yes, madam. I know the accused Vanlal Ramrao Puya, who is present in the court today. I went to the police station to obtain police verification certificate for my employment with Deltin Royal. I told the OC that once I had to go for training to Deltin Royal, and I might stay back, and it might be difficult for me to come in the near future. When the OC heard this, he requested me to attend the court. That is why I have come to the court today. In the year 2007, our family came to Aizawl due to my father's transfer. Since 2007, I have been living at Chuampui, Aizawl. I have had training in Muay Thai with the accused, and sometimes the accused used to teach us when the instructor was away. I made my statement before the Chief Judicial Magistrate Srimati Sylvia Zedralte in connection with this case. Before my statement was recorded, I was administered oath by the said magistrate. Exhibit P7 is my statement. Statement which I made in Exhibit P7 was made voluntarily, and it is what I have known regarding this case. I was shown one iPhone black and white color in the court today, and I know that this is the same iPhone which was given to me by the accused. Police seized the said iPhone. Exhibit P8 is seizure memo. P8 is my signature. M2 is the said iPhone. Apart from what I have stated in Exhibit P7, I have nothing more to say. I was carried by the accused in one scooty, Rodeo RZ black color. When I was riding as a pillion rider in the said scooty with the accused, the number plate was covered with paper at the back, and it was written as MZ01K3085. I was shown the scooty today in the court premises, and I identified the same to be that which was used by the accused on 4/1/2015, that is Sunday, to carry me as pillion rider. When I asked the accused whose scooty it is, he told me that he purchased it, and also he said he was working at the Reliance. The cross-examination. Number 1, it is a fact that the accused Vanil Ramraupuya was my friend, and in my statement to the police, I also stated that I did not know him committing any crime. 2, it is a fact that I did not make any mark on Exhibit M2 in order to make me realize that it was the same iPhone seized by the police. 3, it is also a fact that I did not make any mark on scooty in order to make me realize that it was the same scooty seized by the police. Number 4, it is a fact that I recorded the registration number of the scooty on a paper, and I can say it without seeing the scooty immediately. 5, it is not a fact that whatever I stated in Exhibit P7, statement before the CGM, was made by me as instructed by the police. 6, it is not a fact that when I rode on the scooty, I did not see the registration number written on paper. 7, it's not a fact that I'm deposing falsely in the court today. She was re-examined by the prosecution. I can identify the Exhibit M2 as the one which was given to me by the accused, and there was a scratch mark at the edge of the iPhone, even though I did not put any separate mark. And further cross-examination, it is not a fact that I did not see any scratch mark on the edge of the iPhone. So that was the deposition of Zoming Liani, to whom the accused had pledged the iPhone.
The owner of the scooty
Yes, my lord.
was Julie.
Julie, yes, my lord. Julie is the sister-in-law of the victim. The
She owned it.
deceased.
Now, has she been examined?
Julie was. My lord.
See
Julie
from the
was-
list of witnesses.
Yes, my lord. She was not examined. My lord, it's Judy Lelbiak Feli,
That is page 120.
page 120.
Where was it recovered from? The scooty?
As per the disclosure statement made by the appellant, it was discovered near the dumping ground.
We'll see that recovery memo to say whether it was on his to ascertain whether it was on his instruction and therefore recovered during the course of search. By that time, he had been arrested.
Yes,
It
my
was a
lord.
formal arrest.
Yes, my lord.
Now, let us see that Judy or Julie
Yes, my
sister-in-law.
lord.
Where-
120.
Page 1?
120.
120.
Yes.
Yes. If I may read, my lord. I have not known the I have not known the accused. I am the sister-in-law of deceased Lalnunmoy Zadeng. I am the owner of Scooty Rodeo RZ black color bearing registration number MZ01J 6893. I purchased the said Scooty before I got married to Deng Tan Tluanga. When I came to the house of my husband, I brought the Scooty along with me. I know the deceased Lalnunmoy Zadeng was working in HDFC Bank Longklai branch. I do not know the rank he held during his service. On the night of 31/12/2014 at about 10 p.m., my brother-in-law, late Lalnunmoy Zadeng, told me that since he would not stay in Aizawl for a long time, he wanted to visit his friends and requested me to lend my Scooty. At that time, he said that he would come back soon, and I told him to buy some cold drinks on his way back. He took my Scooty and went out. While he was away, I prepared some snacks at home and tried calling him at about 11 p.m., but I did not get any response from him. I also sent a message to his mobile phone informing him that snacks had already been prepared. We waited him till 12 midnight. As he did not return till 12 midnight, I, my husband, and one of my husband's friends took what I had prepared. I also kept some snacks for my brother-in-law, Lalnunmoya. As the deceased Lalnunmoy did not return even up to 1 a.m. on 1/1/2015, I sent a text message, Ilaw hodon to him, which means, are you coming home? In reply to my question, I received a text message from the phone to which I had sent the message that, Kung ka local may rau ka chante ina karyak don, which translates as, you may lock the door, I will be staying over at my friend's house. Though the text message was originated from my brother-in-law's phone, I do not know who actually sent the text message. As the deceased Lalnunmoy Zadeng did not return, our family members started searching him. As we could not trace him for more than 2 to 3 days, we approached the YMA of our locality and also informed the police by our relative. On 8/1/2015, we were informed by some person, and from WhatsApp, we came to know that one dead body had been recovered at Falkland. On the same evening, some of our relatives went to Falkland and identified the body to be that of Lalnunmoy Zadeng. On 9/1/2015, police personnel from Bongkon PS called and informed us that they had recovered the Scooty used by the deceased on 31/12/2014. I went to the PS and identified the Scooty as the one belonging to me and which had been taken by my brother-in-law. When I identified the Scooty, I found that the original number plate missing, and I did not find any number on the body of the Scooty. Apart from this, one pillion driver's handle was also found missing. When I saw the Scooty, I opened the seat and found the umbrella which I had kept in the Scooty. I also checked the chassis number of the Scooty and found to be that shown in the registration certificate. Thereafter, I approached the court for release of the Scooty on Zimanama. On the basis of the court's order, I took out my Scooty, wristwatch, and bracelet belonged to deceased Lalnunmoy Zadeng on Zima, and I brought the Scooty today to the court. I had taken my registration certificate on the basis of court order dated 9/12/2015, and I brought the certificate to the court today. On 27/1/2015, the vehicle registration certificate was seized by police from my possession. Subsequently, it was released to me on Zima. Exhibit P16 is the seizure memo of registration certificate. P16
Now, please come to the recovery memo of the Scooty. There are two other things that we have to confirm. Postmortem and the forensic expert with respect to blood body knife. As to what happened. Then that thing that came out. This was a very good investigation. It could happen only because the mobile phone was picked by the rack picker. And it was dumping in front. When I say it was just anything. Otherwise it would never have been. But all these files, they were known. That where did he go was all known. Scooty recovery.
Yes, my lord.
तो हमको देखना है 27 में आए.
3. My lord,
The registration card is at 413.
Four zero two is the seizure memo.
Miss
of the
Linda,
scooty.
you in the meantime, just find out the page. We would, after this, we would like to have the medical evidence of the doctor who conducted the postmortem. Before that, the recovery of the dead body, what was the condition, the inquest, and postmortem, it was absolutely decomposed. Because the dead body has been recovered on 8 after the occurrence took place in the night of 31st of December. So we would like to see that inquest, the recovery of the dead body. Just find out the pages and let us know. In the meantime, we'll ask her the medical evidence and the forensic evidence with respect to recovery of knife and the blood on it, whether the blood was tested. Yes. Could you find out?
My lord, it was just here. I lost it again. This one. Yes, my lord. 402 is the seizure memo of the scooty. Page 402. It was recovered from Chuampui. Chuampui. Description of the place is Kacha Road. And the property was seized on 9/1/2015.
Based on the statement made by the accused.
Yes, my lord, the disclosure statement is at page 407. But
So this is in Mizo.
yes, my lord, it's page 148.
My brother will understand it.
407.
408. Sorry, 408 is the translation.
Translation, all right.
If I may read, my lord. Today, dated 9/1/2015, in the presence of the following witnesses, I, Vanlal Ramropui Silo, son of Lalrin Sang, late of Chuampui Gorkhali Veng, who was arrested in connection with the above mentioned case and now under police custody, make the following disclosure on my own free will. On the night of 31/12/2014, late in the night, my friends and I were just sitting outside Chuampui market area, and a certain person came on a scooty during this time. Henry spoke to him and he called me near them, and they asked me where to purchase alcohol. I told them I was not certain as it was already late. He told me that he has 2 bottles of white rum, and he asked me if I wanted to drink it with him. I went on his scooty to drink the alcohol with him. He asked me if I knew a secluded place at World Bank Road. We took a turn near the stone chips machine, and he parked his scooty on the side of the road. We went up near a house that was green in color, and we drank alcohol together. While drinking, he made a move on me and he started touching my private part. He even took off his clothes. I rejected him and we had a fight. I decided to lock him and his body gets limp. I checked his pulse, and upon realizing that he was dead, I decided to slit his throat right under his chin so that it would appear as if he was being touched by others. I took his wallet, scooty, and mobile phone, and I left his scooty at Chuampui below Malco, near a big concrete building owned by Mr. J.L. Thanglwaya. As for the mobile phone, I exchanged it with some drugs from a drug dealer that I do not know. I took off the scooty number plate, and I do not remember where I threw it. That was his disclosure.
Just a minute. This leads us to the statement made by the accused. Statement made by the accused whether he was
not a disclosure.
You will do. Yeah. This is
Not a disclosure.
nothing about scooty. Where is it kept?
It is in the last line of the
Left his scooty at
paragraph.
Conway.
I took his wallet, scooty, and mobile phone, and
I
I left his
I
scooty
left
at-
his scooty at Thompui below
below
Mulko.
Malko,
So
near a big
recovery,
concrete
recovery.
building.
You showed it somewhere near.
Chuampui.
But then he was seen riding the scooty afterwards.
Yes, my lord. He was seen riding the scooty afterwards, but then he
Ultimately-
must have kept it near.
But when was this disclosure made?
It was made on
9/1.
9/1/2015 after his
Before-
arrest.
Before that scooty is the same place. Just see.
The scooty was recovered at Chuampui, which is at page 402. Place from where seized, recovered, Chuampui.
7:40 p.m.
7:40 p.m. 9/1/2015.
Just a minute. वो तो identify भी हो गया scooty everything. Recovery इसकी correctness कितनी है?
At Conway.
Detailed, it's not written in details, my lord.
This Conway when? This Conway.
This was after the death. Immediately after the death.
The body was recovered on 8/1/2015, and he disclosed his statement on 9/1/2015 after he was apprehended.
This is a short statement which he has made. The recovery memo of knife,
Knife.
that recovery also would have been made after 9th.
That
No,
is
it was,
my-
dead body was recovered on 8th.
The body was recovered on 8th, the knife was recovered on 9th.
Where is that?
Just give me 1 minute, my lord. 383. At page number 383. The knife was recovered 20 meters away from the dead body.
Where did you get it? 20 meters from the dead body?
My lord, it's in the depositions of the PW's PW number 12, which is at page 99. PW number sorry, page 98, yes, my lord. The cross-examination is at page 99. And the one who found the knife, his PW number 11, which is at page 96.
No, the death was not because of slitting of the throat.
Yes, my lord, as per the PMB report and the doctor's report.
And there was no, I mean, he wouldn't have used that
Muay
neck-
Thai
that
method.
lock,
That lock.
that lock technique.
Yes, my lord.
There is no fracture of the neck. But then the body was completely decomposed, all maggot-ridden body.
My lord, if I may state, the dead body when it was found, clothes were on. His clothes were on when the dead body was found.
They take time to decompose, no?
No, my lord, the clothes were on. His clothes were on, and as per the
No, that is not relevant. We are not looking at it from that point of view.
he
we are not
was
looking at
naked
it.
at the time when the appellant had left him.
No,
So there can
We
be
can't-
somebody in between that. If
no, no, no. That's a very far-fetched argument. How did he die? How did he die? There is no fracture of neck. Otherwise, then wasn't it there is no. There is a cut injury. That's not. The doctor did not know.
Probably the one was rather than I. Even now, nothing is. 8 days have gone.
Very strong, very strong. Scooty. Knife we can discount. Scooty, dead body identification, so the uncle has identified and many others. Telephone is the biggest thing. He took that telephone. It was pawned. Person, she took it. Okay, so. And then ultimately, IMEI number also has been disclosed. The same number 2580. That is. But how did he come to know about it? How did he open it? How did he change to Papuis?
my lord, my. Yes, my lord. Yes, my lord. Yes, my lord. First of all, my lord, I would like to state that there was no premeditation of the by the accused. Yes, my lord, no mens rea was formed. Due the fact that the scooty, my lord, he did not admit that he had killed the victim in his 313 statement. There was no intention. Yes, my lord. He was being advanced. The victim. Yes, my lord. My lord, that was one. Yes. As I have stated earlier, my lord, that his clothes, when the body was recovered on 8/1/2015, his clothes were on, which is also written in his in the inquest report at page 376. Wearing apparels is black jeans, pants, black full sleeve T-shirt, white pajamas, brown shoes, brown shoe and
Now,
shoeless.
this is
and
there is some gap here. In his disclosure statement, we are looking at the disclosure not for the purposes of finding guilt. We are looking at the disclosure only to ascertain the recoveries, for it to be taken in evidence
Yes, my lord.
during the course of investigation, because he was under police custody and he made that statement.
Yes, my
Now
lord.
he says that he had even taken off his clothes. Does he say that he took off his t-shirt? Does he say that he took off his lower garments? No. And then here they had a fight. So where is that space which you say that he had no time and before he could change he was killed? And this is guesswork. We can't do this. At least at this stage we'll have to believe that he was fully clothed. That statement has to be discounted, that he made advances. Are you understanding?
Yes,
I mean, the logic goes this way, that if the clothes were on and the inquest says that yes, he was not naked, even though the body, even the teeth had given way, the sockets had become decomposed. In that case, we'll have to believe this and discount that statement, because it's a confession. It could be anything. Because the purpose was not that. Now, if it were the purpose to defend himself against his advances, against the advances made by the accused, he would not have taken the mobile phone and scooty. He would have run away.
My lord, as per his
So therefore, that
he was an
statement is absolutely incorrect. He may have done that. Now, this is an explanation. Even if you assume that he made that statement means nothing. He made some advances, therefore he killed. He has not admitted. His admission also would not matter that he had done this. He had killed him for taking away his scooty and mobile phone. If it were for protecting his body from that sexual advance made by the deceased, as it is being pointed out, one question was asked by one of them, that the manager who knew the telephone and who had suggested the name of the telephone and who had given the password and all that. So he says that I have no idea. I was surprised at the question in the cross-examination, but now I realize that this was based on that statement. Well, that statement is not supported by any evidence, even collateral evidence of any kind. So that clothes on, again rejected. Now, third argument.
Okay, my lord.
Now we are only analyzing. I mean,
Yes, my
correct. You can't improve upon the case. No, no matter how much efforts you may put in, you cannot improve upon the case. So if you have thought of other point, tell us.
My lord, my points were those, and the fact that there was no intention in the beginning, like when both of them had gone out separately.
Your strongest point is that notwithstanding the decomposed body which was subjected to post-mortem examination, the cause of death is not ascertained. Neither there is flesh would have decomposed. There is no break of neck, which would have otherwise killed him, because
Yes,
that's a
my lord.
combat game. He is an expert at it.
Yes, my lord.
He gave training also.
Yes, my lord.
So that is one. Number two, it is not, that could not have been ascertained. Slitting of throat, whether it was blood loss, neurogenic shock, or whichever, because the body is totally decomposed. We are accepting that statement of some of the PWs who have identified the dead body. That's because of clothes. Dead body can be identified even at that stage of decomposition. But then, that's the only ground which causes some doubt. Now leave aside that, the cause of injury. The circumstantial evidence are two. Now it is proved that you had the mobile telephone owned by him.
Yes, ma'am.
Correct? Because INEI number cannot be tampered with. There was, the shopkeeper knew. The shopkeeper took out the retail outlet. It was, name of Mr. Zading was there against the purchaser. So this was the number. That is how it was traced. Telephone was pawned. Recovery is from the person before whom the phone was pledged.
Yes, my lord.
Correct. So all
No
this.
denial in that.
So therefore, this is one of the strongest circumstances belonging to him. Number 2 is scooty. Scooty is of the sister-in-law. He had taken it, that is for sure. When he had taken it, it was not there. The same scooty has been recovered because that corroboration comes from the evidence of taking off of the number plate, putting a brown paper or black paper over it, and the registration numbers. Registration number, it is proved that it is the sister-in-law of the deceased who owned it. Now it was recovered there. Nobody has reported.
Yes,
There is no statement in the entire investigation that somebody had saw an abandoned scooty and he had informed the police. No. So therefore, those two circumstances are the strongest circumstances we discount for the knife. Because knife proves nothing.
Knife proves nothing.
Whether knife was used, knife was not used, even if it were recovered, how does it matter?
Yes, ma'am.
If we are not taking the statement, the confession statement made by the accused into account, only for the purposes of fixing it with recoveries, then that doesn't make any sense. Knife is always there, it has been discovered long time back, so what? So that is not our concern. Our concern is scooty and telephone. This is how we test. Now this has to be explained. Where is the explanation? How come?
My lord, that he
that's-
did not deny that he had taken both of them.
So
My only argument is that he was being provoked.
he was?
He was being provoked, my lord, and with that,
We would have agreed in our effort to look at the case from all possible doubts, we would have agreed to it. Only when the man would have died with his telephone and a scooty left there. Taking away the scooty of a man who has been killed, who has died, and then the third theory is last seen.
as per his statement, he was not dead at the time when he left the body.
His body had become limp. Now where? Is the same place where the dead body has been
Yes, my
recovered.
lord, that is
It has
right.
not been carried anywhere. It's the same place.
It's the same
Now
place.
knife we are discounting it for the reason that there is nothing on record which can indicate that he was carrying a knife, number one. Because he's an employee of the bank. He is not a regular criminal.
Yes, my lord.
He is not a regular criminal. So he is not, of course, a drunkard or maybe interested in drugs, but then he was not, we don't know whether he was carrying a knife. Why did he carry a knife in the night of the last day of the year when he is going on a celebratory ride? Why should he? Not for self-defense or something. So that we are not very impressed with. But these two are very strong circumstances and there is no gap. It becomes very clear that he was there, Mr. Zadeng was there with the accused, with the deceased. Zadeng was the deceased.
Yes.
The accused was with Mr. Zadeng in the night.
Yes, my lord. There's no denial of that. They both were
The
together.
your argument, therefore we take into account that there is no cause of death determined.
Yes,
One.
my lord.
Number
As
two,
per the-
the story of knife appears to be the handiwork of police. And therefore, the police has jumped to the conclusion it's a faulty investigation. Number three, this is how we look at it. We are suggesting points. I mean, all this can be taken into consideration. The third is that there was no friendship. Henry and what is the other person?
Henry and Daniel.
Daniel, they were known to the deceased.
Only Henry knew him.
Henry called.
Yes.
Henry called him, and then suddenly he becomes so close. But three of them took a ride on scooter. Where was Henry dropped? Where was Daniel dropped? We don't know.
My lord, they took a ride after the incident, it seemed, as per.
It is after the incident. It is
not
after the incident.
Before that.
But this does not appear to be very, very logical that he would be introduced to the accused. The deceased would be introduced to the accused, and then he goes along. Maybe for taking a ride to a place where he could get liquor in the night.
The victim had liquor with him, so the accused went with him.
Circumstances.
As per his deposition, he had white rum, and they both had it. And
Yes.
Yes, Your Lordship. In order to substantiate the chain of circumstances, Your Lordship, if I may take you to the postmortem report, Your Lordship, that is 429. And in this, it is written that time since death is about 5 to 7 days. So
That's
the
fine.
time of death and the time the accused has left the deceased.
That's a rough assessment.
Yes.
All right.
So there is a change of circumstances which lead to the guilt of the accused, Your Lordship. And another thing is that, Your Lordship, with regard to the disclosure
They couldn't
statement.
decipher. The doctor couldn't decipher the cause of death.
Yes.
But he can say about
say that the time of
possible
death.
time.
Yes.
How can that be said in a decomposed dead body?
And
See, time is often measured by the appearance of that stiffness. What is that called? Rigor mortis, and it's coming out of the body when it limpens. So this is 8 days. The death had taken place in the night on 31st. Postmortem was on 9th of January.
Yes.
So therefore, there was no indicator for the doctor to know how far. Of course, a rough assessment, and he knows when the dead body was recovered. That we discount. That's no chain.
And another point is that the disclosure statement, Your Lordship. The disclosure
statement, don't read. You know the law about it.
Yes. And the Honorable Supreme Court has laid down that if it is lead to the recovery.
Supreme Court will refer later. Talk about the circumstances and the chain.
And the change of
Sequence-wise.
circumstances, again leading to that, is that, Your Lordship, after as per the statement of the.
See, if you have to prove the case on behalf of the prosecution, you have to build up your case.
Yes.
You make chain from the beginning, the way it was investigated.
Yes, Your
Now
Lordship.
the uncle comes and informs the police station that, oh, look here, my nephew left in the night and he has not returned, please find out. The FIR was registered on 2nd of January. Now thereafter, on 5th, there was an information from the police station, concerned police station, that a dead body has been recovered. On that basis, PW1 went and identified.
On 5th, the
No,
purse,
on
the
5th
wallet,
something happened. No?
wallet was.
On 5th,
Wallet
wallet was recovered.
Yes.
Wallet was identifiable, it was traceable to the deceased because of the HDFC card and photograph.
Exactly.
And the photograph published in the newspaper of missing person. So it all started with that photograph.
Yes, Your Lordship.
And then independently of that link, the dead body was recovered by the police station. They would have seen. There is no evidence which says who informed the police station. Nothing. The IO says that I have no idea, unless somebody else has been examined. And then dead body was identified. And in that connection, on the next day, the telephone. So these are the sequence.
I heard Miss Emily and the amicus curiae and Miss Vanessa, APP. Hearing concluded, judgment is.
Obliged.
Next call करिए उनको कहेंगे he will just ask him to be ready. We'll hear you from 2 o'clock.
Yes, Your Lordship.
The court resumes. In the meantime, you concretize your arguments. You have seen the way the bench deals with the evidence.
I'll do that, Your
Correct.
Lordship. Yes.
So that is the way in which we would like you to address us. You're the amicus or you're appearing for them?
I'm amicus, Lordship.
You're amicus?
Yes.
It's a jail appeal.
Jail appeal.
Just formulate your arguments. You did a good job. You were aware of which evidence was placed where.